Hello everyone, welcome to the broadcast of Law Tailors. The focus of today will be the jury system, and specifically whether the jury system undergoes a fair process in the court cases. Our first guest speaker for today will be introducing us the jury system in UK. Please welcome Lamha. So what can you tell us about the jury system in UK?
Alright. Trial by jury is a common law process that was introduced to England dating as far back as 8 centuries ago. The method was, however, established as a matter of right in the provisions of Magna Carta in 1215. Since then, there has been no question about trial by jury being an imperative aspect of the common law process, although there have been many arguments as to whether it is a fair procedure. To begin with, jury is commonly known as a body of citizens sworn to give a true verdict according to the evidence presented in a court of law. Juries are only used in about 1 to 2% of criminal cases, as the magistrate deals with most criminal offenses. The use of juries is reserved for serious offenses such as rape, murder, and etc. The principle of this process is that 12 people will be randomly summoned from the registered voters to observe the arguments presented, evaluate the presented evidence, and review on the facts and reach the verdict in correspondence with their jury instructions and the rule of law. The Juries Act is the main governing legislation that regulates the jury system by signifying the people eligible for jury services and making provisions for the right to challenge jurors. The objective of the jury system is to provide a just and fair outcome that could not otherwise be achieved by judges alone. Juries are meant to be representative of the public conscience. The idea is that juries may acquit a defendant in situations where a guilty verdict is demanded by the law. This prevails in the case of R.N. Wong, where it was made clear by the House of Lords that a judge can never instruct a jury to convict a defendant. The jury system is therefore considered an important part of the confidence society has in the criminal justice system. The problem, however, derived from this method of random selection is that every now and then it may produce unrepresentative jury. The glaring situation of the unrepresentative jury can be particularly seen when a non-white defendant faces an all-white jury, as seen in the case of R.N. Ford. The case concerned motor offenses, subsequently established the standard platform for multiracial jury. The defense was convicted and subsequently appealed on the grounds that the judge had been wrong to refuse his request for a multiracial jury. However, the Court of Appeal upheld the principle of random selection as the most suitable way to earn fairness and therefore confined that the trial judge had no power to empanel multiracial jury and no power to discharge a competent jury so as to obtain a multiracial jury. The imbalance occurring in such cases does not give the trial judge many options to redress the problem. Furthermore, there is no regulation specified that judges have the authority to remove any jurors for the reasons regards to mixed racial jury. Thus, it is hardly to say that a fair justice will be served in this kind of situation. According to Harold Feringa, he speculated about 85% of cases litigated are determined in the stage of jury selection itself. He believed jury selection to be a science in itself. Nevertheless, a development to limit jury trials had been established in the Criminal Justice Act. By this enactment, the judge has the right to dismiss a jury when there is a real and present danger of jury tampering or where a jury tampering has taken place. As a result of this new regulation, the first serious offense to be held without a jury in England for more than 350 years took place in 2009. The case concerned 4 men accused of 1.7 million armed robbery at Heathrow Airport, London in 2004. After 3 juries had been seized due to jury tampering, the 4th trial took place before a single judge. And at the end, all 4 defendants were convicted This case illustrates the modern form of justice which had been done for the sake of society and the legal system. It is also important to take note that British women were not allowed to serve their civic duty as a juror until the Sex Disqualification Removal Act in 1990 came into effect. It was still difficult for women to qualify as a juror because a juror had to own property worth at least £10, which is worth roughly £4,000 today. In 1974, there was still very few female jury as female homeowners were very much in the minority. However, these days, almost everyone in the UK can be a juror. There are certainly several causes for disqualification, including having a criminal record. You can be excused if you're in the armed forces. The others can only refuse jury service for once. Failure to respond to the summons or turn up when required can lead to a £1,000 fine. Now women can even excuse themselves from trials that may offend their feminine sensibilities. Thank you.
Thank you, Lamha.
Guys, so the picture of the defendant is out and take a look. I mean, take a look at it. Can you relate? Like, he's guilty.
Why?
Are you joking? I mean, the skin color.
What?
Now that we have introduced the jury system, the next speaker will be talking about whether the jurors racially stereotype defendants. Please give a round of applause to Christina.
Before we answer the question of whether jurors racially stereotype defendants, we must ask what that means. So it is when jurors are inclined to racial stereotyping, which is to prejudge others using pejorative stereotypes based on perceptions of race, color, descent, or national or ethnic origin. This creates a lack of impartiality within the jury, which may affect the outcome of a trial when deliberations are based on racial bias. Jury is also supposed to function as a reasonable man in a trial. When they have racial bias, this no longer becomes the case. Safeguards are in place to ensure that there is no bias. When juror racial bias is alleged, the courts must consider the complaint by the juror. Before the verdict is made, the judge may discharge the jury or up to 3 of the 12 jurors. This is in line with Articles 6 and 14 of the European Convention for Human Rights, which states that it is illegal to discriminate on a wide range of grounds, including race. It is also stated in the International Convention for the Elimination of Racial Discrimination, or the ICERD. However, research has shown that these safeguards may not be sufficient to prevent racial bias. There has been several instances when a jury has been shown to display racial stereotyping. For example, in R.N. Mirza, the defendant was a Pakistani man who had resided in the United Kingdom for 13 years. He used an interpreter at a trial, and following queries from the jury, the judge gave a direction that no adverse inference should be drawn from this. The letter sent by a juror suggested that there was a failure to follow this direction, with the jury believing that the use of the interpreter was a devious ploy, showing racial stereotyping. Because the letter was sent after the verdict was made, the claims were not allowed to be reviewed. This is due to the jury secrecy rule, which was put in place to ensure that number 1, the verdicts were final, and 2, the jury were protected from any pressure or inducement to explain or alter their views. However, this rule seems to have a disparate effect on negative effect on minority defendants. Besides that, in Gregory and UK, one juror alleged that the other jurors were making racist comments and jokes, which was denied by the others. The trial went on, but the judges reminded the jurors of their oath. Besides that, there are also cases when jurors were dismissed due to evidence of racial stereotyping. In R and Mudar, the defendants were an Asian and mixed race couple. A juror was discharged when an anonymous telephone call to the court clerk was made alleging that a juror had made racist remarks and had decided to prematurely convict the couple. A second juror was dismissed following more complaints from fellow jurors. The evidence seems to show that the majority of claims alleging racial bias seem to fail. Although courts are required to review allegations of racial prejudice, it is up to the court's discretion to determine whether or not it has affected the trial. Despite historical evidence of the English legal system not being sympathetic to racial stereotyping, a study in 2010 for the Ministry of Justice found that the race of the defendant did not affect jury verdicts, even in cases of all-white juries. Furthermore, the 2017 Lammy Review, which is an independent review on minority ethnic groups in the criminal justice system, found that juries were able to keep race out of their decision-making. And all juries were consistent, irrespective of the ethnicity of the defendants. Besides that, a 2007 report found that while jurors are influenced by the race of defendants, it did not affect their final verdicts. In conclusion, although evidence seems to point to the fact that jurors do racially stereotype defendants, what is more uncertain is whether or not this affects the final outcome of the trials. Thank you.
Do jurors know what to do when improper conduct happens in the jury room?
Dear jury, you may proceed with the deliberation of deciding whether the defendant is guilty or not guilty. I have to go now. I'll help you out, okay? I'll help you out. Please get up. Okay, I have to go now. Oh, okay, we're almost at the jury room.
So right now we're supposed to decide whether or not we think the defendant is guilty.
I'm going to update on my Facebook and say the defendant is guilty now.
What's wrong with you? I just spoke to the defendant's brother and he was so nice to me. And not only that, he said the defendant wasn't even on the scene, so I don't understand
But the
how...
evidence
Shut
shows
up!
that-
Let me talk. So he said that the defendant wasn't even on the scene, and I just don't think that he's guilty.
Okay, I don't think you're supposed to bully other jurors. I'm just saying.
So have you guys come into an accordance?
Yeah.
So you guys can go to the courtroom right now. Oh, what happened? You look depressed. Anything I can help?
Look, I saw one of the jurors speaking to the defendant's brother, and I also saw her bullying another juror, and I don't think that's fair.
That's bad. That's really bad. I will reflect this to the judge, and some serious action have to be taken.
Alright.
Here to shed some light on this issue is Ong.
Thank you guys, thank you. Nice to meet you. Thanks for spending so much in inviting me.
It's our pleasure.
Of course, please take a seat.
So, first of all, let's define what is a jury room. Jury room is the place where the jury goes to after the judge has summed up the case. The jury must decide whether or not the prosecution has proved beyond all reasonable doubt that the accused is guilty of the crime with which he or she has been charged. So the next question, what are the improper conducts in the jury room? In Thompson, the Court of Appeal called for an assessment of how best to ensure the collective responsibility operates in jury trials. The 2012-13 research explored the extent to which jurors are likely to report different forms of improper juror behavior, and if they are, to whom they are most likely to report this. Each juror was asked to indicate what he or she would do if 6 different types of improper conduct occurred when serving on the jury. All of the scenarios were based on actual occurrences in jury trials. The findings show that jurors are most likely to report instances to the court of potential jury tampering. Almost all, or 92% of the jurors, would do exactly what they need to do, namely informing the jury manager, usher or judge if someone involved in the case tried to speak or contact them personally. 94% of the jurors would do the same if they see someone associated with the case speaking to a fellow juror. If a juror introduced additional information into deliberations that had not been presented in the trial, up to 14% of the jurors said that they would not do anything about it because they did not feel comfortable doing so. If a juror used a mobile phone in court, only 10% would not feel comfortable reporting it. But why is there reluctance in reporting in such a context? Survey shows that up to 78% of all jurors had used the internet in some way during the trial. So they themselves might be using the phones as well. When it comes to the inappropriate conduct of fellow jurors to each other in the deliberation room, this is where the jurors feel most comfortable dealing with the situation themselves and speaking directly to a juror who may be acting inappropriately. If a juror was unduly pressuring another juror to reach a verdict, up to 39% of jurors would speak to the juror concerned or other jurors about it. If one juror was not giving another juror the chance to express a view about the case in deliberations, 46% of the jurors said that they would deal with this internally by speaking to the juror concerned or other jurors about it. This can be explained where the same situations occur in jurors' working fields. Two, in that jurors might have been facing working colleagues with bad behavior, and that the jurors are more experienced in working in a group by dealing with these problematic group mates. These findings present substantive evidence that jurors need better instructions on what, how, and when to report concerns to the court. It is also important to emphasize one consistent finding in this part of the study, regardless of all the scenarios involved. The results clearly show that 2 points of contact for juries are crucial in preventing juror contempt and ensuring that any evidence of improper conduct is brought to the court's attention. It is vital in terms of ensuring that no miscarriages of justice occur as a result of the jury process that becomes difficult, if not possible, to examine later. And second, it is important to jurors avoid committing contempt. All 6 scenarios, it was the jury managers and ushers, but not the judges, that the overwhelming majority of jurors said they would go to if they were going to report anything they felt might be wrong. This finding has important implications for staffing in the Crown Courts and highlights the need to ensure that these positions are properly staffed, resourced and trained in all Crown Courts in England and Wales.
Thank you, Ong. Here to discuss the topic on how internet affect the jury system.
Oh, are you using the internet? I don't think we're allowed to use the internet.
Are we not? Pretty sure we can.
Let's welcome Eva.
As a general rule, jurors misusing search engines such as Google and social networking sites such as Facebook or Twitter compromises the state of the court as it threatens to prejudice a jury's perception of a defendant and affect biasness. Courts are increasingly battling the problem of jurors conducting online research. According to preliminary research led by Professor Cheryl Thomas, almost a quarter of jurors are unclear about the rules regarding internet use in a trial. It was found that up to 5% of jurors believe that there are no restrictions on their use of internet during their trials, with a further 2% believing it is permissible to look up information regarding their case so long as it does not influence their judgment. The study also found that jurors are less likely to report instances of fellow jurors misusing the media than other behavior. This further illustrates that jurors are unaware of what constitutes improper conduct, and so are not even able to report issues where they may arise. This gives way to the prospect of jury contempt, which is an issue that is prevalent. Despite the precautions taken to ensure the jury remains unbiased, at the end of the day, even at the most high-profile cases, most juries are returned to their own home where they are technically free to make private inquiries online. The consequences for a juror's private inquiries on the internet are grave. In high-profile cases, it is very difficult for jurors to avoid internet news reports because of media coverage, especially for jurors who read news online or accessed their emails through websites that presented the news title in the homepage. Based on the study by Professor Cheryl Thomas from University College London, jurors who hear high-profile cases were 7 times more likely to recall media coverage than jurors who hear standard cases. In recent years, a few juries had to be discharged or trials needed to be abandoned because of jurors' improper use of the internet. For example, in 2005, after the verdict of Adam Karakaya was given, where the jury found him guilty of rape and assault, a jury bailiff found internet printouts in the jury room. The defendant was then acquitted in a retrial after the judges decided his conviction was unsafe in the Court of Appeal. The use of the internet clearly intervenes with proper conduct in a court of law. In 2011, a juror was prosecuted for contempt of court for using the internet as well, and its consequence was a sentence of 8 months of jail. Joanne Frail, aged 40, admitted at London's High Court for using Facebook to exchange messages with the defendant. The judge remarked in her ruling that her conduct in repeatedly referring to the internet was directly contrary to her oath as a juror. The Lord Chief Justice acknowledged that it was a serious offence. There was another case in the year 2012 where a juror conducted online research on a criminal defendant. Theodora Dallas is a former university lecturer who was serving as a juror at Luton Crown Court. She conducted the research on the criminal defendant, which is Barry Matlock, at home. The judge had put a stop on the trial after Dallas told the members of the jury that she conducted research on Matlock. Matlock was still found guilty after retrial. Dallas was found guilty of contempt of court by 3 High Court judges and was jailed for 6 months. This case shows that courts are facing increasing problems in preventing jurors from using internet research on cases, because the usage of internet is common nowadays. Moreover, UK citizen has the highest level of internet engagement in Europe. With regards to reporting possible misconduct of a miscarriage of justice, the Law Commission recommends that there be a way which ensures a member of the jury be able to report their concerns to the Criminal Case Review Commission and to the court. However, the usage of the internet by jurors during the trial poses not only a threat from the point of view where jurors may look up research about a particular case, but also goes against their oath as a juror when they use the internet as a means of discussing the case at hand outside of court. 2 jurors, Yusuf Beard and juror Qasim Javi, were found guilty of contempt of court and sentenced to 2 months in prison. In conclusion, it is because of these reasons then that the Law Commission finds it necessary to impose strict criminal liability upon jurors, especially in an age where information has been made readily available online. Thank you for having me.
In conclusion, there are evidences that show that jury racially stereotype defendants. However, some studies that was mentioned previously did prove that there is no bias among the jury. With the current jury secrecy rule, people will not know the statements made in the jury room because there is a common law rule that do not allow examination after the verdict was announced. This reduces the public's confidence on the jury system and increase the possibilities of indirect discrimination among minorities defendants. The public may think that the jury did not come to a verdict based on evidences. It is clear that there are still possibilities that jury will be biased in the trial, but it is not certain that bias will greatly affect the decision of the trial. There is a report which is called the Are Juries Fair report. The report found that the jurors needed new tools to help them to have a better understanding of the court process. Trainings should be given to the jurors before listening to criminal trials so that they have knowledge on their role and responsibilities. Jurors will also avoid improper conduct in the jury room once they are aware of the rules. In the current digital era, most people use social media on a daily basis, and this includes the jurors. Based on the points mentioned earlier, there is a chance that internet might affect jury trials. According to a survey conducted by University College London, 23% of jurors were not clear on what is permitted and what is not allowed. Some jurors thought that using the internet for research was allowed. Professor Cheryl Thomas said that the rules on using new media is confusing for a small group of jurors. The effect of internet to jury trial will decrease if the confusion on the rules are clear. There are 2 factors that can improve the fairness of the jury system. The factors are accountability and transparency. The more secretive the jury system, the greater possibility of biasness. Transparency of the jury system can improve the fairness of the jury system, but accountability is also crucial. Greater accountability is where juries need to explain their decisions. In this case, biasness will reduce significantly. Jury trials plays an important role in the criminal justice system, as most of the time, the jurors are summoned for criminal cases. The citizens' participation in the criminal justice system are necessary as UK is a democratic country. Juries represented the opinion of the society and they are not case-hardened as the judge. The jury should not be affected by external factors when making the decision of a case. This shows that it is crucial that jury is not racially biased so that justice can be upheld. Moreover, the jurors took an oath before every trial that they will give a true verdict according to the evidence. The public will be more confident on the jury system if the decision made is fair and just. A fair jury trial also provides reassurance to ethnic minorities and shows that everyone is equal before the law. This is the end of today's broadcast.